The notice wasn't slipped under the door or mailed with a polite header. It was slapped unapologetically onto the glass window of Pam Bondi's office while her back was turned mid-consultation with a client. In bold red letters, it declared a municipal code violation and a fine of $95,000, effective immediately. Below the amount, a brief citation of Local Statute 17C offered the only explanation. No warning, no prior summons, just a number, a statute, and a threat. It wasn't just an administrative move, it was an ambush. Pam stood in silence as her assistant peeled the notice off the glass, her eyes scanning the language like a prosecutor reading a last-minute indictment. Her client shifted nervously, unsure whether to stay or leave. But Pam wasn't thinking about the room anymore. She was calculating. Someone had pushed the system in motion without due process, and she knew that only happened one of two ways: incompetence or intent. This didn't feel like a clerical error. It felt like a message. The timing was strategic. End of the fiscal quarter. Her schedule packed with pro bono hearings, a city council petition on housing code reform, and a pending lawsuit against a developer with deep ties to local officials. She had made enemies, but never openly, never directly. That was the currency of American legal warfare: silence, leverage, and buried knives. But today, someone had chosen to make it loud. She didn't wait for a hearing notice. She made the call herself, demanding to know why such a fine had bypassed every procedural safeguard she knew was legally required. The clerk on the other end of the line stammered, then placed her on hold. When they returned, they told her a hearing had been scheduled for that afternoon, 3 hours from now. No explanation, no apologies, just a cold timestamp. Room 2C, Judge Marcus Clay. Pam had heard of Clay. A long-time fixture of the Hillsborough County Courthouse, his rulings rarely made headlines, but his name surfaced often in backroom conversations. The kind of judge who prided himself on swift decisions and despised unnecessary arguments. He had a reputation for favoring efficient justice, which in many cases meant predetermined outcomes wrapped in formalities. If her case had landed in his courtroom, it wasn't by accident. The drive downtown felt shorter than usual, as if time had compressed in anticipation. She didn't bring her full briefcase, there wasn't time, but she had everything she needed. The statute in question, prior case law, procedural checklists, and enough legal memory to fill in any gaps. This wasn't her first fight, but something about this one felt different. The courthouse bustled with its usual rhythm: officers, attorneys, bailiffs, defendants. But Pam moved through it like she was walking upstream. Every hallway felt more narrow than the last, every door more resistant. Room 2C was already open when she arrived. No line, no chatter, just a half-empty gallery and a clerk marking attendance. Her name was already on the docket. Inside, the room felt colder than she remembered. She had argued cases here before: civil disputes, zoning appeals, a handful of community litigation cases. But never like this, never with this weight. She took her seat at the defendant's table, alone. No co-counsel, no legal team, just a single folder and the posture of someone who had nothing to prove, but everything to defend. Across the aisle, the city's legal representative, a young man she didn't recognize, sat with a laptop and a thin stack of papers. He looked uneasy. He didn't greet her. That wasn't protocol, but it also wasn't a good sign. It meant he knew what was coming, or at least suspected it. If he had expected an easy win, her presence likely changed the script. The minutes ticked by with no announcement. Then, without fanfare or warning, the door behind the bench opened and Judge Marcus Clay entered. He didn't glance at the counsel tables. He didn't ask for opening remarks. He didn't even sit all the way back in his chair before speaking. He opened with the ruling. That's when Pam knew the real hearing wasn't happening in that room. It had already happened, somewhere else, without her. This was just the performance to make it look legitimate. The amount remained the same: $95,000. Violation of 17C. Payment expected immediately. No opportunity given to enter a plea, dispute facts, or challenge the basis of the citation. The judge declared it as settled law, then looked to the clerk to record the outcome. But Pam didn't move. She didn't nod. She didn't pack her things. She simply sat still, the gears turning behind her eyes. She wasn't surprised by the amount. She was surprised by the speed. It wasn't just about the fine. It was about the silence they expected from her. A rubber stamp, a bowed head, a quiet exit. But silence wasn't something she had ever been paid to deliver. Pam didn't rise. The clerk waited, her hand hovering near the docket, as if time might push this case forward on its own. Across the aisle, the city's attorney stared straight ahead, avoiding her gaze, avoiding everything. The judgment had been entered, the fine declared. But Pam hadn't said her last word. She hadn't said a single word yet, and that was the point. She reached for the file in front of her, not because she needed it, but because movements in courtrooms are statements. She opened it slowly, deliberately, letting the sound of rustling paper echo in the silence that followed the ruling. Not a rebuttal, not a protest, just presence. A presence that refused to be erased with a gavel and a signature. Then she looked up at Clay. The judge, already shifting toward the next item on his docket, paused, not out of concern, but out of irritation. He wasn't used to being held in place. Pam saw it in the way he leaned back, the barely perceptible pause before he adjusted his robe. She knew this courtroom like the back of her hand, and she knew when its rhythm had been disrupted. The ruling had landed, but its authority hadn't. She lifted her hand, not high, not demanding, just enough to claim the space that had been denied her. The court officer glanced toward the bench, uncertain, but Clay gave a single nod, almost dismissive. She had 5 seconds to say something before the full force of judicial indifference rolled over her like concrete, so she used it. She asked a question, not to the judge, but to the law. Not to Clay's ego, but to the system itself. A question so basic, so foundational, that it cut through every layer of formality. If a person is fined under a statute without being allowed to speak, without evidence presented, without even a documented violation, then what separates enforcement from persecution? Clay didn't answer. He didn't need to. The answer was already crawling up the walls of the courtroom, vibrating under the floor. The silence of the gallery turned from disinterest to attention. Even the court reporter sat up straighter. Pam turned the page in her folder again. Another signal. This wasn't over. It hadn't even begun. Then she moved, slowly rising to her feet, not in protest, but in position. A defendant? Perhaps, but also a witness to a process that had skipped the process. She named the statute, she cited the section. She referenced 3 prior rulings where the same law had been deemed unenforceable due to vagueness, where courts had ruled that fines without documentation violated constitutional protections. She did it without raising her voice, without appealing to emotion, just the cold, documented spine of the law, the kind that couldn't be argued away with a gavel or a title. The city attorney shifted in his seat, then leaned forward as if preparing to interject, but he didn't. He had nothing prepared for this. His file was only a few pages thick. Pam's memory alone outpaced his binder, and he knew it. Clay sat still, listening but unmoved, not because he disagreed, because he refused to yield. That was the game now, not law, not justice, control. Pam knew it. She didn't press harder. She pivoted. She brought up Reynolds v. Clearwater, a ruling that invalidated an administrative fine issued without evidentiary review. She quoted the judge's opinion verbatim. She let the weight of the precedent settle like dust over the bench. Then she added the final piece. If this ruling stood, she would file for appeal, and in doing so, bring the entire practice under review. It wasn't a threat, it was a promise, delivered with surgical clarity. Not for Clay's sake, but for everyone in the room watching. She wasn't fighting for a reversal. She was building a record. That's when Clay spoke again. His voice was clipped, cold, but beneath it there was something else. Hesitation, not fear. Calculation. He asked if she was threatening the court. She didn't respond with denial or apology. She responded with the law. The balance shifted. Suddenly, Clay wasn't the only one in charge. The courtroom, once quiet in passive obedience, leaned in. Attorneys in the gallery began taking notes. Clerks exchanged glances. The tension had become tangible, legal, not theatrical. Pam had done more than interrupt a ruling. She had cracked the illusion that this courtroom ran only on authority. She had reminded them all that it also ran on accountability. Clay raised his hand, cutting off the city attorney as he tried again to intercede. The judge's eyes locked on Pam. A pause, long enough to measure, then came the concession. She may present her defense. Pam didn't smile. She didn't nod. She simply sat back down, opened her folder once more, and began preparing for a trial that, until 5 minutes ago, wasn't supposed to exist. The judge had given her permission, but not willingly. This was not a gift. This was a doorway she had forced open, and behind it was a system that no longer felt quite so untouchable. Pam didn't waste a second. As soon as the judge's reluctant nod cleared the path, she gathered her materials with the quiet precision of someone sharpening a blade. Not because she needed to organize. Every argument, every precedent, every case citation was already etched in her memory, but because control in court wasn't just about the words you spoke. It was about the order in which you delivered them, the weight they carried, and how tightly you wrapped the law around the silence. She started with the statute itself, Local Statute 17C. On the surface, it seemed straightforward, a provision that allowed the city to levy fines for failure to comply with municipal code. But Pam didn't focus on the surface. She went straight to the language in subsection B, the one cited in her violation. She pointed out how the phrase reasonable noncompliance had been ruled unenforceable in 3 separate cases due to its ambiguity. She named each one, spelling out the judicial logic that followed. She didn't look at the judge. She didn't need to. She looked at the gallery, at the faces of the people who had sat through hundreds of cases and had come to expect predictability. Today, they were being reminded that precedent had power. That law, when wielded correctly, was sharper than any authority. The room held its breath as she continued. She shifted next to the concept of due process, not as a vague constitutional right, but as a legally required safeguard that courts had a duty to uphold. She laid out how administrative fines, especially those issued without evidence, without opportunity for rebuttal, violated basic procedural fairness. She referenced Henderson v. St. Petersburg, where the appellate court had overturned a nearly identical fine due to lack of notice and the absence of documented violation. She let the names of the judges in that case fall like stones on the record. These weren't abstract theories. These were facts, published, recorded, cited. They couldn't be dismissed with a wave of the hand or a narrowing of the eyes. They were binding. Across the room, the city attorney flipped through his binder. His page movements were no longer deliberate. They were desperate. He had walked into the courtroom expecting routine procedure. What he found instead was a wall of case law he wasn't prepared to scale. Pam saw it, but didn't flinch. Her next move was deliberate. She requested that the court call the enforcement officer who issued the fine. The moment the request left her lips, the weight in the courtroom shifted. It was a gamble, but one she calculated perfectly. Either the city had no officer available, or they would be forced to put someone on the stand who likely never expected to testify under oath that day. Clay hesitated, then gestured to the back of the room. A man stood, Officer Brian Hale, mid-40s, regulation haircut, posture of confidence layered over discomfort. He made his way forward, took the oath, and sat. Pam remained standing. She started with the basics. Was he the officer who issued the citation? Yes. Did he observe the alleged violation personally? Yes. Did he take any photographs of the violation? No. Did he file a written report? No. Any witness statements? No. He leaned on his years of experience and instinct, but instincts weren't evidence, and Pam knew exactly what she was doing. She turned back to the bench, her voice steady as she framed her next argument. The absence of documentation, she said, stripped the fine of any legal standing. According to the appellate ruling cited earlier, enforcement of a municipal fine must include evidentiary support. Anything less was a violation of procedural law and an invitation for abuse. Mendez, still seated beside Clay, took notes. He didn't speak. He didn't need to. His silence now held more power than words. Clay's jaw tightened. His fingers drummed once, then stopped. His eyes remained locked on Pam, as if daring her to push further. But she already had the advantage, and now she was simply tightening the noose. She brought out a printout of public records showing that in the past 2 years, 4 cases involving similar violations under Statute 17C had been either dismissed or overturned due to procedural flaws. She placed the records on the table for the clerk to enter into evidence. Clay didn't stop her. The city attorney finally stood, trying to redirect the court's attention back to the clarity of the statute itself. But Pam was faster. She asked him directly, How did he reconcile the court's current enforcement of the statute with the Henderson ruling? He didn't answer. He couldn't. The courtroom fell into a silence so thick it no longer felt procedural. It felt personal. Pam stepped back, letting the weight of her case speak louder than her presence. For the first time since walking into room 2C, she had done more than challenge the ruling. She had dismantled the foundation it stood on. Clay looked over at Mendez. No words exchanged, no signal made, but the tension between them was visible in their stillness. Then Clay leaned forward, cleared his throat, and called for another recess. Pam returned to her seat, knowing exactly what that meant. The system wasn't ready to fall, but it was bending, and the weight pressing down on it had her name written all over it. The recess felt strategic, not a pause for rest, but a recalibration. Pam remained seated, her papers untouched, her focus uninterrupted. The courtroom emptied slowly, conversations hushed and speculative, as if the building itself had absorbed the tension and didn't know where to place it. Outside, she imagined Clay pacing behind closed doors, not reconsidering his position, but plotting the next move, because power rarely surrendered without a contingency. When the courtroom doors reopened, it was clear that the weight of this hearing had shifted from legal formality to political calculation. Judge Clay entered first, followed by another man in judicial robes. He walked with quiet command, older, more reserved, but unmistakably significant. Pam recognized him immediately, Judge Harold Mendez, senior judge of the appellate circuit. A man rarely seen in lower courtrooms unless summoned for oversight, damage control, or both. His presence was not just unexpected, it was unprecedented. Clay returned to the bench, his demeanor stripped of the composure he had worn earlier. He cleared his throat, voice carefully leveled, and announced that due to the procedural concerns raised, Judge Mendez would be joining the bench as an observing authority, a term that meant nothing and everything at once. Pam didn't react, not visibly, but inside she understood what had happened. She had pushed the hearing out of its designated lane. She had forced the system to show its scaffolding. Mendez addressed her directly. His tone was not adversarial, but neither was it warm. He acknowledged her arguments, then referenced Henderson v. St. Petersburg, the same case she had built her foundation upon. He reminded the court that a subsequent ruling had clarified that some applications of Statute 17C could still be enforceable under localized discretion. It was a clean maneuver, a narrowing of precedent, a pivot back toward Clay's authority. Pam heard it for what it was, an attempt to seal the opening she had torn through the statute, but she didn't hesitate. She folded her hands and responded, not with interpretation, but with precision. She reminded Mendez that the same follow-up ruling also imposed strict evidentiary standards on enforcement actions taken under discretionary authority. Standards that in this case had not been met. No photos, no statements, no documentation, just the opinion of one officer and a rubber-stamped citation. Mendez offered no immediate reply. Instead, he turned to Clay, who remained silent, expression unreadable. Then Mendez asked if the enforcement officer who issued the citation was still present in the courtroom. He was. Officer Hale stepped forward again, called back to the stand. He didn't look surprised, only reluctant. This time, Pam didn't walk to meet him. She remained behind her table, letting her voice project with calm authority. She asked if he had received specific training on Statute 17C enforcement. He had not. She asked if he had been instructed to issue citations based on visual assessment alone. He had. She asked if he had consulted any codebook or municipal checklist before issuing her fine. He hadn't. Everything, he admitted, had been standard protocol. Pam repeated the phrase aloud, then asked if he could define what standard protocol meant, since no documentation of it existed in any city record she had subpoenaed. He couldn't. The courtroom sat in silence as his uncertainty solidified her argument. This was not enforcement. This was habit disguised as law. Pam then addressed the bench, carefully choosing each word. Without tangible evidence, she explained, any fine issued becomes a matter of personal interpretation, which is the exact vulnerability the appellate court warned about. Without checks, there is no process. Without process, there is no law, only power. Mendez remained impassive. Clay avoided her gaze. She continued. She presented data. 4 prior cases from neighboring counties, each dismissed due to lack of evidentiary support. She laid out the timeline. She quoted from written opinions. She cited municipal audit findings that showed a pattern of unverified citations issued under the same statute. She didn't offer conclusions. She delivered facts. When she finished, she stepped back, not physically, but rhetorically. She had pushed every point to the edge. Now she waited to see who would cross it. Clay looked exhausted, but not defeated. That was the danger. Judges didn't need to win to feel victorious. They needed to endure. And Pam had no illusion that logic alone would shift the scales. But then something changed. Mendez leaned toward the clerk and spoke softly. A murmur followed. Then silence. Clay called for another recess. The room stirred with confusion. Another break so soon? But Pam knew exactly what was happening. They were regrouping, not because she had broken the law, but because she had broken the script. And now they needed time to rewrite it. She remained seated as the bench cleared, her hands still, her case made. Whatever came next, it would not be routine. And the courtroom, once a place of silent compliance, was now a chamber of reckoning. The second recess lasted longer than the first. The courtroom remained half full, but no one left. The usual shuffle of paperwork and quiet conversations gave way to a waiting silence that carried tension like static. Something had shifted, not just procedurally, but psychologically. The hearing was no longer about a fine. It was about a boundary, who drew it, who enforced it, and who had the courage to step over it. Pam didn't rise. She stayed at the defense table, still, composed, watching the doors. She knew this tactic well. Recesses weren't always about fatigue or scheduling. Sometimes they were about control. When the law became uncertain, power reached for pageantry. When the judges returned, it was clear the dynamic had changed. Clay entered first, eyes forward, jaw set. Mendez followed, his usual judicial calm intact, but his body language more reserved. It was the posture of someone choosing observation over intervention. The message was clear. The weight of the decision would remain with Clay. The judge adjusted his robe, cleared his throat, and addressed the room. Pam had presented compelling arguments. Her points were noted, her citations reviewed. Her tone, her delivery, professional. It was a performance review, not a ruling. And then, with the same gravity he had used to impose the original fine, he stated the court's position. The fine would stand. There was no elaboration, no legal rebuttal, no reference to precedent. Just an assertion wrapped in authority, placed back on the record like a stamp of finality. Pam didn't flinch. She listened carefully. Then, without hesitation, she turned to the court stenographer and asked for the last statement to be read back into the record. It was done with mechanical precision. The fine stands. Pam looked back at the bench, and in that moment, she did something Clay wasn't expecting. She reframed the question, not as an objection, but as clarification. Was the court officially stating on record that a municipal fine could be imposed without any evidentiary documentation, in contradiction to established appellate precedent? Clay didn't respond immediately. His fingers moved slightly on the bench, a visible pause. Then, in a measured tone, he stated that the court had discretion. Pam acknowledged the point, but didn't concede. Discretion, she reminded him, was not immunity from legal standards. It was a privilege rooted in consistency. If discretion allowed punishment without proof, it wasn't discretion. It was arbitrary power. The city attorney stirred uncomfortably in his seat. The argument was veering into dangerous territory, not legally, but institutionally. It questioned not just a ruling, but the very function of the local judiciary. Pam stood now, her voice steady, not rising, but resonating. She outlined the consequences. If the ruling stood, it set precedent, not legal precedent, but cultural. It said that evidence was optional, that a citation could rest on one person's word, unverified and unchallenged. It said that a homeowner could be punished without knowing why, that a business could be fined into closure without recourse, that a citizen's right to defense could be silenced with a gavel. The room was still, heads turned, eyes lifted. Pam turned to the gallery, lawyers, clerks, everyday observers, and reminded them that justice was not about efficiency. It was about transparency. And if the system began to favor silence over scrutiny, the law would rot from the inside out. Finally, Mendez spoke. His voice was calm, but his words carried weight. He asked whether Pam was arguing that allowing this fine to stand would undermine not only due process, but the integrity of the judiciary itself. She said yes, because the moment rulings were upheld without evidence, the court became a gatekeeper of power, not a guardian of rights. Clay's hands tightened on the bench. There was no easy response to that. To rule against her now was not just a legal decision, it was a public stance. The gallery would hear it, the transcripts would reflect it, and the appeal which Pam had already prepared in her mind would turn one courtroom into a stage for a much wider review. The city attorney made one last attempt to intervene. He began to speak, but Clay raised a hand. Silence returned. Then, after a long pause, Clay exhaled. The court found that the fine, as imposed, failed to meet the evidentiary threshold required for enforcement. The judgment was reversed. The citation voided. There was no applause, no celebration, just a subtle shift in the room's air pressure, as if the truth had finally been allowed back in. Pam offered no reaction. She didn't need to. The victory was in the ruling, but also in the reckoning. She had not only won, she had forced the court to confront itself. Clay tapped the gavel once. Court adjourned. Pam gathered her papers slowly, not with triumph, but with clarity. The courtroom was already beginning to stir, files being closed, chairs scraping softly, clerks exchanging glances without speaking. The ruling had landed like a stone in still water. Ripples would follow. But for now, everything held in quiet suspension. She didn't look back as she walked toward the exit. She didn't need to. The silence behind her told her more than words. The ruling was final, but the reckoning had just begun. Just as her hand reached for the polished brass door handle, Judge Clay's voice broke the stillness behind her. "Miss Bondi." She stopped, but didn't turn around immediately. When she did, it was with the calm of someone who no longer needed to ask for permission to speak. Clay didn't stand, he didn't soften, but his voice carried something new, something reluctantly human. He told her he had underestimated her. Pam said nothing in return. She didn't need to. That sentence didn't require a response. It wasn't an apology. It was an acknowledgement, one that would echo beyond that courtroom long after she was gone. As she stepped into the hallway, the tension of the room gave way to the quiet hum of courthouse life. Clerks moving between hearings, footsteps on marble. The air outside the courtroom somehow felt heavier now, as if it carried the weight of everything unspoken in that trial. But Pam knew better than to exhale too soon. She hadn't made it 15 feet before a voice stopped her again. This time it came from behind, not Clay's, but someone with a different cadence. She turned to find Judge Mendez approaching, alone. He walked without ceremony, his expression unreadable, but his presence unmistakable. They stood in the hallway, flanked by closed doors and fluorescent lights. No cameras, no microphones, just two people who understood that what had just happened inside that room would not stay confined to it. Mendez didn't ask for small talk. He didn't offer congratulations. Instead, he studied her for a moment before saying what Pam had already suspected. He hadn't been brought in to observe. He had been brought in to contain. Pam didn't blink. Mendez went on, not out of duty, but out of a quiet conviction. Clay hadn't acted alone. This hearing hadn't been just about a code violation. It had been about optics, about power, about making an example. Pam wasn't supposed to argue. She was supposed to comply. And when she didn't, the system sent backup. But it hadn't worked. Mendez warned her what she did today would not go unnoticed. Not just in this courthouse, not just in this city, but further, higher. There were people watching now, people who preferred quiet lawyers with short memories and no appetite for confrontation. Pam listened, not with fear, but with focus. She asked no questions. She gave no promises. Mendez nodded once, then left her there, standing under the humming lights, folder still in her hands, the smell of institutional floor wax clinging faintly in the air. She turned and continued toward the exit. Outside, the sun had dropped lower in the sky. The courthouse steps stretched out in front of her, wide and empty. Her heels clicked against stone with quiet finality. The city hadn't changed. The law hadn't changed. But something had. In that one hearing, a single fine meant to silence had unraveled the very method used to impose it. A courtroom that prided itself on efficiency had been forced to reckon with its own shortcuts. And a judge who once relied on his position alone had been made to speak in complete sentences. Pam knew the story wouldn't end here. It never did. Systems didn't shatter from a single crack, but cracks multiplied. They grew, echoed, called attention to the very weight they held up. And now there was a record, a ruling, a precedent, a challenge issued not just in legal terms, but in moral ones. Justice wasn't just preserved, it had been demanded. And someone, somewhere, had just learned they couldn't count on silence anymore. Pam walked the length of the plaza slowly, not because she was tired, but because endings deserved pace. The courthouse loomed behind her, tall and institutional, its steps still echoing with the weight of moments that had, until today, always favored silence. Ahead, the city moved on. Traffic lights blinked, pedestrians flowed, coffee carts steamed into the wind. The world outside hadn't paused for justice. It never did, but that didn't mean it didn't notice when it happened. She reached the edge of the block when a voice called out once more, "Miss Bondi." It wasn't sharp. It wasn't official. It carried no command. She turned slowly, and this time the man walking toward her wore no robe. His suit was dark, his tie loose, no briefcase. Just a man who had spent the day behind a bench, now stepping down without the barrier of elevation. Judge Mendez didn't offer pleasantries. He didn't disguise his words behind legal framing. He simply stopped beside her and said what others wouldn't. "You're good." Pam met his words with the kind of quiet acknowledgement that needed no repetition. She didn't ask why he was there. She knew. He looked back toward the courthouse, then lowered his voice, not to whisper, but to ensure no one else heard what he was about to say. "I wasn't brought in to oversee the law," he told her. "I was brought in to neutralize you." There it was, stripped of euphemism, the truth that had always sat beneath the surface. The court hadn't called him because of concern over process. They had called him because someone, somewhere, believed Pam Bondi needed to be managed, not heard, discredited, not debated, and they had failed. Pam didn't show satisfaction. She didn't take the bait of validation. She simply asked him what came next. Mendez hesitated, not out of indecision, but because some truths were heavier than others. "You'll be watched," he said, "carefully. Not all the time, but enough. People will smile to your face and brief against you in the same breath. You've reminded them that compliance isn't automatic, and that makes you dangerous." Pam nodded once, not in agreement, in understanding. They stood there for a moment longer, neither of them offering goodbye. Mendez turned first and walked back the way he came, toward a building that would remember the day, even if its occupants pretended not to. Pam continued on. She didn't head straight for her car. She walked deeper into the city, past the legal offices, past the banks, past the quiet courtyards where mid-level bureaucrats sat sipping coffee as if nothing ever shifted beneath their feet. She passed the library where she used to study constitutional law on weekends, and the nonprofit clinic where she once represented tenants for free. She passed reminders of why she had entered this profession in the first place, places where law was not a ladder to climb, but a shield to hold. Her phone buzzed 3 times while she walked. Reporters, colleagues, a cautious congratulations from someone she hadn't heard from in a year. She let them ring. This wasn't about visibility. It never had been. What she had done that day wasn't flashy. It hadn't gone viral. No headlines would scream about a reversed municipal fine or a procedural ambush unraveled. But somewhere, someone would read the court transcript and recognize a pattern they'd seen before. Somewhere, a young lawyer would cite today's case to buy themselves 5 more minutes in front of a skeptical judge. Somewhere, a city official would hesitate before issuing a violation without cause. Those moments mattered. Quiet victories mattered. She stopped near the corner of Jefferson and Morgan, where the shadows grew longer and the traffic began to swell. The city was still loud, still moving, still indifferent. But she stood still. Because power didn't always come from a title. It didn't always sit behind a bench or hide behind procedure. Sometimes it came from one voice refusing to be small, from one person unwilling to nod when something demanded a shake of the head, from someone who asked a question and kept asking when everyone else stayed silent. That was the truth of justice in America. It wasn't guaranteed. It wasn't granted. It was insisted upon. Pam Bondi didn't walk out of court that day with applause or acclaim. She walked out with a record, a precedent, a message. That power, when left unquestioned, grows careless. That law, when wielded without conscience, erodes quietly. And that silence, when mistaken for submission, is the most dangerous illusion of all. Thank you so much for taking the time to listen to today's story. We hope it left you with something meaningful to reflect on about justice, courage, and the quiet strength it takes to stand up for what's right. If you'd like to support our channel, simply hit the like button. Leave us a comment letting us know which country you're watching from and how the story made you feel. And don't forget to subscribe so you won't miss what's coming next.